Hi, Hector Aguilar with Aguilar Realty Group Homes, and today I'm accompanied by Paul Velasco, one of the state's utmost authorities when it comes to estate, trust, and probate law. Paul, thank you for taking some time to sit with us.
Of course.
Can you tell us a little bit about you and your firm and what you do?
Yes, sir. So I'm a certified specialist by the California State Bar in estate planning, probate, and trust law. So I've been practicing for 20 years, and we have a firm of about 9 attorneys and staff of about 25 people that work exclusively in estate planning, probate, and trust law. So this is all we do.
Wonderful. Well, again, thank you for taking some time. I wrote down a couple of questions so that we can talk about some topics that maybe the public or homeowners may not be familiar with.
Okay.
So one of the questions I asked was, that I have wrote down was, what is estate planning and what is the difference between a will and a trust?
Those are two good questions. So estate planning is interesting because when I became an attorney and started practicing law, and you hear the word estate plan or estate planning often, I never really knew what that meant. In fact, I thought that estate planning was really for the wealthy, for the millionaires of the world, and it really didn't include me. But what I've come to know, as I've practiced for many years, is that estate planning is for everybody. Everybody needs estate planning. If you own a home, if you have any assets whatsoever, you need an estate plan. Because what an estate plan is and what it does, it answers the question, what would happen to your family if something happens to you? Do you have the proper documents in place to ensure that if something happens to you, your family's not going to end up in court? Because the way California law works is that if somebody passes away or dies and they have assets in their name individually, which of course all of us own assets in our name, if that happens and you pass away and you don't have the documents in place necessary, like a will or a trust or powers of attorney, then in order to pass your estate on to your family, to your heirs, that's going to have to go through a process called probate.
Understood.
It's a very long, detailed process, and it's very costly, very time-consuming and expensive. So the way that you avoid that is by having a written plan in place to avoid those kinds of court actions.
Wonderful. So that particular plan is what we would typically call a living trust, correct?
That's correct. So you asked the other question, what's the difference between a will and a trust?
Right.
So the main difference is probate avoidance. Okay.
Okay.
So a will, everybody knows what a will is. A will is simply a document that states your wishes about where you want your property to go when you pass away. And in there you'll express who you would want to be the executor of your estate. So having a will is certainly better than nothing because at least it expresses what you want. What most people don't realize is that everybody is actually born in California with a will. Either you did it yourself because you went to an attorney, or maybe you did your own will, or the state of California has one for you. So when people die without having a will in place, the state of California has a will. It says where your assets will go.
Correct.
Now, it may or may not be where you would want it to go. So why would you let the state get to decide that? You should get to decide where your assets go. And the only way to do that is to have a plan in place. So a will certainly will do that. The problem with using only a will, however, is that wills are subject to probate. All wills will get probated first. So it'll first go through that court process that we're trying to avoid. And yes, your wishes are expressed in the will, and certainly the property will get to where it's supposed to go when you pass, but it'll first pass through this process that takes at least a year to a year and a half to get through, and it's very, very costly, very expensive. So the difference between a will and a trust is that a trust is a will substitute. A trust is the exact same thing that a will does. In a trust, you name the people that you would want to receive your property, just like you would in a will. The difference, though, is that trust document, which is at its core an agreement, the trust is a contract, and that trust document gives your executor or your successor trustee all the power and authority that they need to deal with the administration of your estate, to get control of your bank accounts, your real estate, your investments, whatever you may own. As long as it's in the trust, we don't have to go through that probate process.
Wonderful.
That document gives them the authority to get control of your assets and then pass the property according to your wishes as set forth in the trust.
Wonderful. So it sounds like really the living trust is a far better alternative than a probate, either through the state, right, or a will. Like you say, even a will goes through a probate.
That's
process,
correct.
right?
That's correct. And the reality is most people don't do anything. Most people have nothing in place. The majority of Americans have done no estate planning whatsoever. So unfortunately for those people, the majority of my practice is going through court actions, dealing with situations in which, because people didn't plan, we're now going through a probate, Or even if they did a will and maybe it wasn't done properly, we're now going through a dispute among the heirs and the beneficiaries and the children.
Okay.
So getting an estate plan and doing it right is going to minimize those problems.
Wonderful, wonderful. You know, it sounds like either you do a living trust to protect your assets, right? Or you allow the state to do the probate for you. It sounds like the probate's really a costly transaction or a costly process. Obviously, the benefit to having a living trust is to avoid probate altogether, right?
Exactly. And the probate fees are based on the size of your estate. So it's not a set fee. The larger is the estate that you have, the higher the cost. So as an example, if all you own is a home in California, if all you have is your home and you want to pass that to your children, and let's say a home in California, you're talking about at least $500,000.
On average.
On average. The probate fees are for a $500,000 estate are $32,000.
Oh,
and that's what's called ordinary fees. That's going to happen no matter what. In addition to the ordinary fees, there may be additional fees if there's litigation or problems with the estate, or there's creditors who are filing claims against the estate and the attorneys have to defend those. Or if there's real property that's being sold, there may be additional costs.
Gotcha.
So we're looking well into the $40,000 range just to probate a house.
Wow.
And if you have assets that are beyond that, of course, the fees go up from there.
Sounds like it's definitely costly to go probate.
It's definitely a big cost that your family can avoid if they just plan correctly.
You know, you mentioned something that kind of hits home with a lot of the Latino community. In general, the American public, they don't plan. And I always say that, you know, if you fail to plan or plan, you actually plan to fail when it comes to your assets and, you know, probate law. So I know that there's a little bit of a stigmatism with regards to, well, do I really want to do a living trust? Because it's almost like there's a connotation like, well, I'm kind of preparing for the inevitable. And the truth is that we all pass. You know, none of us live forever. And the truth is that there's probably a better chance of you protecting your assets to passing them on to your heirs by having a living trust.